So may I move, Mr. Chair, na nag-violate si Atty. Lopez
Undue interference.
proceedings
Okay.
or sa ating trabaho. May I move to cite Atty. Lopez in contempt, Mr. Chair. I move.
Okay, so good day everybody. I'm back for another video at ngayon po pag-usapan natin yung pinaka-recent na congressional hearing kung saan umattend si Atty. Zuleika Lopez, yung Chief of Staff po ni Vice President Sara Duterte, kung saan na-cite po siya in contempt. Okay, so panoorin po muna natin yung video.
In this case, Your Honor, as stated, the audit investigation is still ongoing. It would seem that if the documents would be provided to the end of Congress, it is as if Congress is also conducting an audit process.
We're not conducting an audit process.
Yes.
We're conducting an inquiry in aid of legislation pursuant to the Constitution. Now, tell me, wala pa kayong naipapakita sa akin na paano kami nag-i-encroach doon sa domain ng other branches of government? Show me.
Your
You
Honor,
must remember, Attorney, that we have oversight functions over the
okay.
budget of government. And part of that oversight function is the reason why we can conduct inquiry regarding the use, so that maybe we could change, for example, the joint circular of regarding the liquidation of confidential funds.
Okay, so makita po natin, diba, there are now two legal opinions na nagbabanggaan po, yung legal opinion ng Office of the Vice President and the legal opinion of the House of Representatives. Para po mas klaro tayo, i-establish muna natin ng maayos yung facts. So dito po yung argument ni Atty. Zuleika is that the Congress is stepping in or encroaching on the functions of the Commission on Audit because according to the Office of the Vice President, Congress is already conducting an auditing process, okay? Whereas naman po yung argument or yung legal position ng House of Representatives is that they are not conducting an auditing function, rather they are performing their oversight function under the Constitution. Okay, so para po mas klaro, explain ko po muna kung ano yung dalawang bagay na yon, yung COA and yung oversight function. Okay, so let's start with COA. Yung COA po, as I have explained in my other video, is the Commission on Audit, which is an independent constitutional commission po yan, which was expressly created by the Constitution to perform auditing functions. Yung ibig sabihin po nun, yung COA yung nagper-perform or nagre-review po kung paano nagamit yung pera ng government, whether or not there were any violations or kung nasunod ba talaga in accordance with the provisions po nung General Appropriations Act natin yung paggamit ng pera. Okay? And yung oversight function naman po, this is the function of Congress that is provided by the Constitution, wherein Congress can conduct hearings para po ma-review nila kung nasusunod ba talaga yung layunin or yung pag-enforce sa mga batas na enact nila. So one of the laws po that Congress enacts every year is what we call the General Appropriations Act. At para po sa hindi nakakalam, yung General Appropriations Act, basically yun po yung pera ng buong Pilipinas. Okay? So every year ine-enact po yan ng Congress. Therefore, Congressman Acop is arguing that since the General Appropriations Act is a law, therefore they can exercise their oversight function para ma-review nila yung budget ng government offices, which in this case is the Office of the Vice President. So dun po nagbanggaan ngayon yung dalawa nilang legal positions. So ako po personally, I am very interested na sana umabot or sana may mag-file talaga ng kaso sa Supreme Court regarding this para maklarify po talaga ng Supreme Court kung hanggang saan nga ba yung extent ng oversight function ng Congress in relation to the auditing powers of COA. Kasi kung titingnan po natin with the argument of Congressman Acop, sobrang powerful po ng Congress, di ba? Kasi yun nga po, lahat ng government offices, yung budget nila is covered by the General Appropriations Act. So kung wala talagang limitation yun, yung oversight function nila over the GAA, edi lahat ng government offices basically parang pwede nila reviewin regularly yung paano nagamit. So I am personally very interested po kung ano yung magiging outcome dito. But for argument purposes, for discussion purposes, let's say ako po yung lawyer ng Office of the Vice President, ano po ba yung magiging argument ko dito? I will argue po na the Congress dito, in the exercise of their oversight function, is already encroaching to the auditing function of COA kasi kung makita po natin, nire-review na po nila yung genuineness ng mga resibong sinubmit nung OVP sa COA, di ba? Kaya nga lumabas ngayon yung meme na Mary Grace Piatos eh. So they are already reviewing as to the genuineness, the validity of said receipts. Therefore, Therefore, that is an auditing function already from how I see it. So yun po yung magiging argument ko. At ang nakikita ko dito, I think there was just a lack of explanation po dun sa part of the OVP, kaya medyo nagkagulo na yung OVP at yung HOR, nagkainitan na sila kasi yung OVP is alleging that Congress is already performing an auditing function, pero dun sa letter po hindi nakalagay specifically kung ano yung ginawa that constitutes as auditing. So like I said, ko dun ko po explain ngayon na since Congress is already reviewing the genuineness, the authenticity of the receipt, that can be considered as an auditing function. Therefore, that can be considered an encroachment on the power of the COA. So hopefully klaro po yun.
First, enforcing the subpoena against the audit decision contravenes existing rules on the audit process. Disclosing the reports before the conclusion and finality of any audit is premature and will compromise the integrity of the final report. The Office of the Vice President will be deprived of its right to an impartial tribunal and a fair and objective resolution of the cases. Public statements or discussions thereon by the committee or the Congress as a whole may unduly influence the bodies which are already handling the same or similar subject matters. There are no less than 3 cases on the subject confidential funds that are currently pending with the Supreme Court.
3 cases
Hence,
pending.
compelled disclosure of the audit decisions may be violative of the sub judice rule, which
okay.
restricts comments and disclosures pertaining to judicial proceedings. That wa-
Question of subjudice, malinaw na yan, may Supreme Court ruling yan, di ba? Di ba walang subjudice with regards to inquiry in aid of legislation. Di ba? Ang daming, andyan, may mga jurisprudence na yan. Di ba, do you confer? Di ba, may mga ruling na yan ng Supreme Court with regards to subjudice?
meron po, Your Honor.
O, and that subjudice cannot be applied in inquiry in aid of legislation, malinaw yan.
In this case, hindi pa po conclusive and final yung audit investigation report.
Yung nga yung tinanong ko sa iyo kanina, please tell me if there's a provision of law that prevents us from conducting inquiries in aid of legislation while the findings of COA are not yet final. Meron ba? Sinabi mo kanina, wala eh.
I cannot cite any particular
Then,
law, Your Honor.
you
But
have no basis then.
Ang-
Or your writer, Mr. Ortonio, doesn't have any legal basis to state the thing. Tama. You being a lawyer, puro
our stand, Your Honor, is just extreme caution in discussing matters like this, given
Okay.
that it is still pending investigation. That is the reason why we drafted and requested the Commission on Audit, Your Honor. It was just a mere request and for the Commission on Audit to consider.
Okay, so sabi ni Attorney Zuleika dun is that wala daw siyang ma-provide na law. And nag-agree din siya kay Congressman Paduano na may jurisprudence na sa on sub judice. Okay, so number 1, I agree. There is jurisprudence on sub judice in relation to legislative hearing. However po, I do not agree that the rule on sub judice does not apply to all legislative hearings because in one of the more recent cases po involving the rule on sub judice in relation to legislative hearings, sinabi po kasi ng Supreme Court doon that the filing of an administrative or a criminal complaint should not automatically bar a legislative hearing. Therefore, pwede po mag-bar ng isang legislative hearing ang pag-file mo, just that hindi siya automatic na ibabar niya agad yung legislative hearing. So medyo ang dami na po nating bar, kahit ako naguluhan na po eh. So i-translate po natin, let's say bar means stop. So i-translate natin in simpler words, filing of a criminal or administrative complaint should not automatically stop a legislative hearing. Therefore, pwede niya i-stop ang hearing, just that hindi automatic. Okay? And klaruhin ko lang din po hindi ko naman sinasabi na itong argument ko is a very strong argument. However, sinabi po yun ng Supreme Court in a case. Therefore, that forms part of law of the land. And sa amin po kasing mga lawyers, every time we are engaged by a client, one of our duties po talaga is to find a way to the best of our abilities po to protect the right to life, liberty, and property of our clients. For example, purposes lang, for educational purposes, may client ako na lumapit sa akin tapos naiipit siya in a legislative hearing. Ito po yung gagamitin kong argument kung bakit the rule on sub judice can apply to legislative hearings. And ito pa, another food for thought lang din. Kung titingnan ninyo in that case that I mentioned, ang diniscuss lang dun po ng Supreme Court is administrative or criminal cases. Now, let's imagine if it is a case involving constitutional violations already, blatant, grave abuse of constitutional rights and provisions already. I think in that scenario, more or less talagang papayagan po ng Supreme Court na mag-apply yung sub judice rule, provided lang ma-establish ng klaro kung bakit siya magiging violative of the rule on sub judice. Again, I would emphasize, I am not saying this is parang a knockout argument kasi majority of the discussions sa Supreme Court, sinasabi nila it does not apply. However, in that same case, dun din sinabi yun ng Supreme Court, it should not automatically. Therefore, it can bar, just that hindi nga automatically. Hopefully, klaro po yun So move on po tayo sa next topic.
Okay, Speaker, dahil dito sa sulat na to, Mr. Speaker, sinasabi kasi dito sa sulat na ito na tama ba request lang sa COA na huwag pagbigyan yung aming request for the subpoena.
It was really just a request directed to the Commission on Audit, Your Honor.
Pero Mr. Chair, on the second paragraph nung kanyang letter, nakalagay dito, no, we are of the position that the subject subpoena should not be complied with. Ano po ba ibig sabihin ng should not? Are you commanding? Are you demanding the COA na magsumunod dun sa subpoena dun sa STECO?
If Your Honor, Mr. Chair,
Please continue, Attorney Lopez.
yes, if you read the entirety of the letter, it is really a respectful request sa Commission on Audit. We are not demanding them or instructing them. It is really a respectful request if you read it in the
Well,
entirety.
Yes, oo. Pero pag should kasi parang demanding na yon, commanding na yan para sa akin, no?
And
Okay?
yes, and
Okay,
may
so
I also
kung-
add,
Yes, kung hindi ito demanding, commanding, parang siga-siga ba yung Office of the Vice President na utusan yung OVP, na
Yung
utusan
COA.
ang COA na hindi kami sundin ang Congress or House of Representatives?
Your Honor, Mr. Chair, hindi po siga-siga ang OVP. It is really just a respectful request, Your Honor, for them
Okay.
to consider our position. Like all position papers filed, ito po yung aming, we feel that these are the issues that we needed to raise. So, which we addressed to the Commission on
Quick comment lang dito dun sa should kung saan medyo nag-react si Congresswoman Castro. So in position papers po kasi, in pleadings, when you state your arguments or you state your position, you really have to state po yung gusto mong mangyari. Yun po talaga yung reality. Pero usually sa dulo naman po dyan, meron po yung prayer wherein you will state na respectfully praying to the honorable court, to the honorable office, so on and so forth. Dapat po talaga pag pleadings, demand letters, it should be read in its entirety kasi pag titingnan mo lang yung argument, medyo may chance talaga na mainsulto ka kasi ganun po eh. When you are stating a position, syempre you have to provide your position clearly. Hindi po yung pwedeng parang gusto mo mangyari ganito pero lalagyan mo ng mga paligoy-ligoy na word, because one of the instructions po talaga ng Supreme Court to us lawyers is that when you make an argument, you should make it direct, na there is no room for ambiguity when a person reads it. Pero yun, usually sa dulo yan, meron naman po yung prayer na kung saan respectfully submitting, respectfully praying, and so on and so forth. Okay, so continue po tayo.
Pero dito sa letter na ito, Mr. Chair, may plano talaga ang Office of the Vice President na mag-interfere doon sa ating conduct ng ating proceedings. Dahil dito, Mr. Chair, I'm sorry, Atty. Lopez, no, dahil ikaw yung nakapirma dito, and according to our rule, one of the reasons is the undue interference in the conduct of proceedings. So may I move, Mr. Chair, na nag-violate si Atty. Lopez
Undue
dito
interference.
sa ating proceedings
Okay.
or sa ating trabaho due to this Section 11, Letter F, undue interference in the conduct of proceedings. May I move to cite Atty. Lopez in contempt, Mr. Chair? I move.
Sir, Mr. Chair, before you make the ruling,
Any second?
if I may be allowed,
Any second to the motion?
Uh,
Duly seconded. Is there any objection? Hearing
Your
none, the
Honor.
motion is carried.
respectfully, it was not the intention of the Office of the Vice President to...
Attorney, you wait
Okay.
to acknowledge
Okay,
you.
I'm sorry.
For that,
Apologize, Your
I
Honor.
So napukpok na yung hammer, guys. Pag napukpok po kasi yung hammer, sabihin nun the chair has made a ruling. And in congressional hearings po talaga, the ruling is final once yun. The gavel is nabang, na ganyan. And since may yun, nag-move si Congresswoman Castro, may nag-second, napukpok. Therefore, naging final po yung contempt order against Atty. Lopez. So ngayon, yung next question natin is that legal po ba yung pag-cite sa kanya in contempt? If Congress votes in favor of it, legal po yun siya. Yun yung reality. Because in Congress po, it is always a numbers game po yan. And yung basis nila dito was undue interference. Undue simply means that you did something illegal, something inappropriate. So, Congress ang pumaka-determine kung what is undue interference for them. And based dun sa explanation ni Congresswoman Castro, yung paggawa po nung letter nila kung saan sinulatan ng OVP yung Commission on Audit na wag ibigay yung mga documents na hinihingi ng HOR sa kanila, yun po yung naging rason kung bakit daw may undue interference to their proceeding. So, yan, since napagbotohan na po yun ng members, wala naman pong nag-object, wala po tayong magagawa doon. Yun yung reality po talaga when it comes to the rules of procedure in the House of Representatives. Kasi the House of Representatives po has their own rules that when they get the sufficient number of votes regarding matters, that is considered as approved by the people because yung House of Representatives is composed of representatives representing the people. Yun po yung essence ng House of Representatives. So sa ganito pong situation, kung tingin po ng isang taong na na-cite in contempt is there is improper yung pag-cite sa kanya, pwede po niya yan questionin ngayon under the power of judicial review on the ground of grave abuse of discretion. Yun po talaga yung remedy. Because again, if the gavel was banged already and it was approved by a majority of the members, there is a presumption of regularity unless the Supreme Court declares that there was grave abuse of discretion in the actions of Congress. Yung nakikita ko po talaga dito actually, medyo may banggaan po talaga ng legal opinions. Yung legal opinion nung OVP which we thoroughly discussed earlier in the video and yung legal opinion ng House of Representatives. So in scenarios like this po talaga, ang best remedy po talaga is that pumunta po tayo sa korte para masettle yung controversy or yung issue. Kasi if banggaan lang ng legal opinions, wala pong mangyayari. Hindi naman po yung OVP magde-decide kung sila yung tama, hindi rin naman po yung HOR magde-decide kung yung position nila is yung tama or mali 'di ba? So therefore, to settle sana the issue, the OVP can go to the Supreme Court and file a petition for prohibition against the HOR on the ground of violation of, let's say, the separation of powers, violation of numerous constitutional violations based dun sa inexplain ni OVP. Yun po yung proper remedy. And on the part din naman po of, let's say, House of Representatives, kung sa tingin po nila there is also constitutional violation on the part of the Vice President, specifically yung minimension nila lagi is betrayal of public trust So therefore, pwede rin po sila pumunta sa Supreme Court niyan to question the refusal of VP Sara to attend the proceedings or bakit pinipigilan nila ma-release yung mga documents. So yan po talaga yung reality ng legal system natin. If there is a clash of positions, legal opinions, the best remedy po is to go in court and wag po sanang gawing personal yung away kasi hindi po masisettle yung actual controversy or issue kung kayo-kayo lang mag-uusap. Okay? So hopefully klaro po yun guys. If you want more legal commentaries, legal videos to current events, follow lang po kayo sa akin sa TikTok, sa Facebook, and subscribe po kayo sa aking YouTube. And see you all next time po. Bye-bye!